Hello, welcome to Hay & Kilner. We're a firm of lawyers in Newcastle. We're pleased today to be able to provide a role play dealing with social media as part of your practice management programme. Why social media? Well, I at present am dealing with cases involving the perils of social media, the difficulties that can be caused by reason of social media for employers. Why is it a big issue at present? Two reasons for that. One, the extensive way in which social media is now worked through society, borne out by the numbers of Facebook accounts. At present, it's half the online users in the country having a Facebook account, about 30 million. In terms of Twitter, we're now looking at 500 million accounts worldwide. LinkedIn, which you may have come across being a professional network organization, 175 million accounts. So there's a lot of people using this. In addition to the numbers, it's, to me, the way in which social media changes the way that we communicate with each other. I describe this as a blind communication. Why? Because it's one way. Traditionally, if you were talking to someone, you read their body language, you know where the line is, you know if you've crossed the line, you know if someone's taken offense at something. They show that visually, they might even tell you. The way of social media is one posts things, one puts things in a very one-way mode, and we're not sure if we've overstepped the mark. So in employment terms, where we're effectively dealing with the relationships between people, there are a lot of minefields really in this particular area. How are we going to deal with that today? Well, what we could do as part of this program is simply sit here droning on. We think it'd be a lot more useful to actually create a theatrical aspect to it, tell a story to you, and to demonstrate some of the points that we want to bring out. So we're going to do that by performing a role play. In terms of the two actors in the role play, we will first look at Tom Verlaine, who is the chief executive of a new industry called Marquee Moon, dealing with the new industry of the design of apps and things such as that. Tom Verlaine has asked to come along to see his lawyer, played by Sarah Hall. Why? Because in rehab at present is David Byrne. David Byrne, presently the business development manager of Marquee Moon, been in post a couple of years, previously used to be a designer. Things have started to go wrong recently. He's ended up in rehab, hasn't been seen for some time. We're going to look at another subject which is not within the workforce and within the workplace, but outside. It's how social media can be misused on behalf of the company, Marquee Moon, but in circumstances where the company will be liable and responsible for wrongdoing. So there has been an email passed between Tom and Sarah where Tom has set out these particular circumstances, and we're now going to go into the solicitor's office. The curtain's going to be pulled back, and we're going to deal with that part now.
The second issue we were going to look at is obviously these comments he's been making about Kevin. Right.
Yeah, I've sent the email, and that they are overboard. And I had words with him about it, and he was whinging on to me saying, well, he's done this in the past, and I was pointing out on the previous ones he's never gone so heavy-handed where he's actually, can we say, slagged off the product and then used our name as come and see our apps. Normally we just have a go at the product, we find things wrong with it, so we said it's not as good, it can't do this. But he's just gone out and just wholesale just said, this is just a load of rubbish, to put it bluntly. And I can see why they're upset, but, that's his fault. He knew where the line was. We told him, you don't cross the line with these things because we can end up in problems.
And when you say we told him, is that in the emails you're referring to, or are these verbal discussions?
Well, verbal discussions.
Okay.
We're careful, we don't put anything in writing.
Right. It would have been helpful if you had put something in writing in this case,
Right.
Certainly, because if there's nothing in writing, David could turn around and say that conversation did not happen. So again, we need to have a think about who had the conversations with him, statement from that person so that we can put that to David as part of this process and ask him whether he accepts. Was he aware of this? Does he accept that conversation happened? Again, I presume there's nothing in terms of a policy. I think we covered that off for the last allegation.
Well, no, apart from the emails when we've said, this is what we expect you to do. So the staff knew how they would use Facebook and Twitter.
Okay.
But we know it out of policy because everyone knows, that's how we do it.
Okay. I mean, certainly going forward, we need to put those policies in place because you don't want to have a repeat of this scenario. What you want in the future is just to be able to produce the policy to whoever you're disciplining and to point to the place which says this is gross misconduct or this is misconduct.
Right.
We haven't got the benefit of that at the moment, but again, it doesn't mean we can't do anything. It's just a factor in terms of the fairness of the decision. So in terms of the fact that we knew he was making some comments, is that, for example, you knew that these comments were going out?
Of course,
then?
I get copied in.
Right.
I keep at home and at work, I have a separate screen when I pick all these things up. So there'll be Twitter and Facebook. And I have word alerts where I can pick up relevant messages to the app. So I knew what he was saying, but I mean, he was going just crazy. This was like 3 o'clock in the morning. He was going to be doing that.
So how recently was that from getting the letter from the competitor's solicitor?
That was about probably 2 or 3 weeks ago.
Okay, right. Because again, we talked about last time, if you've known previously things have been happening and you haven't dealt with it formally, the tribunal would question why all of a sudden this was serious enough to merit a dismissal. I assume it's the solicitor's letter, is it?
Well, it is, yeah, but I did have words with him. I did say, hey,
Right.
that's a bit on the heavy side. They're going to take the hump about this, aren't they? And he was just so, I'll let them take the hump,
And did you say to him, well, if you carry on, we may discipline you?
Well, no, I just told him to ease back on the throttle,
Okay. Again, I think the tribunal would find that a difficult situation because I think what they would clearly expect you to have said is if you repeat this behaviour, you are at risk of being disciplined or even dismissed.
Yeah, but you knew what I meant when I told him to ease back on the throttle. He's a director. We promoted him. He knew what the responsibility in the job was.
I think the tribunal would not be convinced by that argument. But again, we look at all of the facts when they come in before we progress it. You also mentioned that other people do this as well. Is David the only one who's gone to this extent, or may there be, again, arguments about consistency?
Well, no, he's the only one. The others have been quite good about it, They just criticise the app itself. He's just gone wholesale and just gung-ho, having a go at them as a company and the apps that they produce. So he's not just picked out the single app.
I think what we need to do is a review of all of this type of behaviour to see, as you say, where do you as a company draw the line is the first question, and then have we made that clear to David and the other employees?
Well, I think we have, we tell them this is the line, you don't cross it. So I think they have to know where the line is. We wouldn't have tolerated this sort of behaviour because the directors have taken it more seriously than I do, because I just think they're not going to do anything, but they think, well, if they do, we could be in problems. Already we're losing money. Because the apps aren't doing as well, and they don't want to have a huge legal bill coming in.
I mean, I agree, it does need to be dealt with seriously, but again, that doesn't mean we jump straight to dismissal. So if you send me all of the emails which have been sent out in terms of where this line is drawn, and we'll see where we are to that point, probably we're going to need to look at statements from the individuals who've also had discussions about where the line is drawn in social networking. And we'll gather all of that information and see what position you're in after that. And again, you meet with David, you speak to him about what's happened, and you give him the chance to put his side
Yeah, but he's in rehab, isn't he? I don't know when he's going to come out. I thought we could just, have a meeting and just tell him we're going to get rid of him. And I got some of the staff have said that they think he's been taking drugs. Surely that's enough where we can say, oh, you've got to go, David.
I mean, if you were to do that, you're looking at a straightforward unfair dismissal. The fact that he's absent doesn't mean you can't invite him to an investigation meeting. His doctors might actually support him progressing this, because until this is resolved, that stress isn't going to be any easier. But you do it in the correct way. So you make various offers. For example, it may not be he wants to come into the workplace. You might do it at a neutral venue. He might want to have somebody with him other than a work colleague. We can deal with all of that. Don't think that just because he's absent we can't progress this. We just need to deal with it in a certain way.
All right, but the directors want this dealing with very quickly. They want me to put a lid on it and move on because we need to get someone in to take over his position straight away. We've been interviewing already.
I think if you speak to the directors and explain that if you do rush this and if you don't follow the correct process, that David is likely to bring an unfair dismissal claim and potentially even a disability discrimination claim if the stress is actually as bad as it potentially sounds, you are talking about substantial awards. And you've already said he's quite a high earner, I think.
Well, he is with his bonuses. He can earn quite, you're not quite six figures, but almost when he's at his peak.
Yeah.
And that's why we took the view, well, look, you're not doing too well now. That's why you're whining. Mm. And he's gone off sick because he's not bringing home the bacon anymore.
Well, but also it does sound like he's got doctors who are prepared to say that he is suffering from stress.
Well, they say anything nowadays, doctors, won't they?
But the tribunal will take that evidence into account. So again, although I appreciate that you're having pressure put on you to move this forward, I think it's a case of saying you've now taken advice, we've got a plan in place, and also if we don't stick to that plan, then there is a real risk that David will bring a claim and he could be talking about substantial damages for loss of earnings.
Okay, well, I've heard what you want to say. Obviously, I'm not happy about it because I thought we made things quite clear to all the employees what we had to do, and I think he's just riding the step now. He knows what's going to happen if he comes back to work. We're going to sack him. Well,
hopefully you have made it clear to the staff, and hopefully we can produce all of those emails as part of this disciplinary process. There shouldn't be any prejudging in terms of a decision, but again, you're only dealing with the investigation. Somebody dealing with the disciplinary hearing should stay completely out of it until the investigation's complete. We can do something about this. I think that is the thing to remember. Just because he's been making these comments on Facebook, even the ones he's doing in his own home out of working hours, you can do something about this. But what we don't want to do is rush to a dismissal where there may be some gaps in terms of the process.
Well, from what you're telling me, we should have had a policy and procedure about this, but it's very difficult in our business because we allow staff to do this. So I think it's going to need some careful drafting, Sarah.
That's fine. There is nothing wrong with encouraging staff to use social networking, whether that's marketing, team building, but you as the employer, as you've said, need to show them where to draw the line. That's being done verbally. We now just need to put that in the form of the policy. The best way to do it is to give clear examples of what is acceptable, what's unacceptable, but also to make it clear, for example, what would be classed as misconduct, so you'd get a warning, but you'd get another chance, and what would be classed as gross misconduct. But we can work through those policies.
Okay, because I think we need to make an example of David to the other staff. I think that's what we like to do, to show them, this is what you can't do, this is what will happen.
Well, certainly you need to deal with him in the correct way, because if you didn't deal with this and somebody else did it, you've got a consistency problem. But again, that's not to say you're going straight to dismissal. So in terms of the plan of action, we're going to meet with David, have an investigation meeting, get all the details we can.
Okay.
We're going to get all of the documentary evidence in terms of print-offs from the Facebook site, emails, etc., emails you sent previously, so we've got all of that down.
Right.
We then need meetings with the staff.
Yeah.
So we can find out exactly what he's been doing, because it may not just be isolated to Facebook. If he is behaving in this way, there might be quite a lot of verbal things they need to put in the statement as well.
Okay.
We need to see David's personnel file, because we need details of things like length of service, any previous GP notes for stress, any training or support he might have had in his management role, because these are all relevant factors in terms of how fair would an ultimate dismissal be. And then as a second part of this, clearly we need to look at your policies going forward.
And then if we do all of this, we can then dismiss him, I presume.
Well, if you do all of this, you've then got a fair procedure in place, and what we'd have to look at is, are we looking at probably a warning, or are we looking at a dismissal? Now, if you're looking at a warning, for example, you might be considering a demotion as well. We'd need to look at the terms of his contract, but what you need to consider is alternatives to dismissal. But we need all of the information before we get to that stage.
Okay, I don't think the director's going to be too happy about this, because they want him out the door.
Well, I'll put it all down in an advice and you can send it to them.
Okay, well, that sounds okay, Sarah. If you can put it all in an email to me, bullet points, then I'll have to start doing the work.
That's fine.
Okay.
Thank you for coming in.
Thanks, Sarah.
Thanks.
Okay, let's just see where we got to on that and see what happened in the future. First point is in terms of looking at the documentation. Some people out there will have their own social media policies at present. We've just recently done a seminar of 75 HR people who were present. Only 4 people actually had policies. So some of you may not have those policies. Even if you have a particular policy, don't just sit on it and think everything's now fine. What is very, very important, as Sarah was demonstrating, was try and assess within that policy where you've drawn the line in respect of wrongdoing, because if not, you will have issues in the future because people won't be informed as to where the line is. They won't know they've crossed the line, and that will cause problems if you then try and discipline them on the back of it. Sarah makes a very good point in respect of when dealing with the placing of the line, use examples. Most of you should have a bullying and harassment policy, and most of those policies nowadays talk about examples. They talk about isolating people. They talk about humiliating people, disciplining people or reprimanding people in a public place. So it's very important to work through. Don't just simply think, oh, well, I've got a great policy there, and it will cover all situations. It should cover your situations. It should cover your concerns. Another point about documentation is, how does that policy link in with other policies? What we get a lot of nowadays is policy after policy after policy. I'm old enough to remember telexes. What is very interesting over the last 10 years is people tend to have a policy to cover faxes, then they have a policy to cover mobile phones. Mobile phone policies was all about really wasting time in the office. Then there was an issue about using the employer's PC, perhaps for booking holidays, perhaps for sending emails to friends. Then there was a situation, development, where most people wouldn't use the PC for that. Now they use their own phone, their own iPhone. So it may well be that that policy now in respect to mobile phones needs to be updated. The whole subject probably needs to be looked at from these different angles. And it may well be that you should have a merged policy. But again, it's not just about the document, it's about thinking through those particular points. What's very important also, Mr. Verlaine wasn't too specific about whether this staff handbook had been communicated properly. He thought it might have been in the canteen or in the office or something. For proving that people know where the line is and how they might be disciplined if they cross it, it is very important to show that people have either signed for policies or they've been put on a notice has been put on a notice board communicating that fact. So after today, what you should be doing is, there are perils of social media. Look at your documentation. Second point from today, peril, disciplining someone. So in terms of just dealing with that at the moment, Mr. Verlaine, was Mr. Byrne dismissed?
He was indeed dismissed.
He was dismissed. And he was dismissed for the 2 charges?
He was indeed, yes.
Bullying his staff internally?
Correct, and overstepping the mark.
And overstepping the mark in terms of heaven and blagging heaven.
Correct, set an
inappropriately.
example, yeah.
And his remuneration each year?
Each year was about 90k with the bonuses.
Right. So with the bonus, what we're looking at here in terms of the peril of dismissing someone unfairly, to break it into figures, is a claim of about £70,000. Within the tribunal, as you may know, there is a cap on compensation, but here this man is so well remunerated that he could be claiming money up to that cap. Also, this organisation now has to defend that claim, and that's going to involve legal costs. It's also going to involve loss of management time. My assessment of dealing with clients, witnesses for a tribunal, is they don't sleep for the week before the tribunal because they're worrying about their evidence and whether they're going to do well or not. They don't sleep certainly for the time of the tribunal, and whether it's gone well or badly, they don't sleep for a week afterwards because they're either telling someone how fantastic they were giving evidence and we blooded David Byrne's nose, or they're suffering because they were treated badly in the tribunal, that they during cross-examination they may have been tripped up, they may have not given their evidence as well as they wanted to. So that's a lot of management time, that's a lot of witnesses taken out of your workforce, so that's a big upheaval. Legal costs, not cheap. It is much better, prevention better than cure. It is much better to save, to use the costs of this exercise and then work on it, to protect yourself, those costs will always be a lot less than fighting the tribunal case. In that particular tribunal case, if you're going to win or lose, what are the issues? Well, the issues are, did he get noticed as to where the line was? He's already accepted he didn't have a social media policy. So there's going to be a question of whether he was on notice as to where the line was. Also, when you're looking at the defence of a unfair dismissal claim, the employer basically has to climb a mountain. It is the employer that has to show that they've acted reasonably. And part of that, have they acted reasonably, involves, does the decision come within what lawyers call the band of reasonable responses? And the employment judge won't say, this is what I would have done in those circumstances. What the employment judge will do is will judge that decision against a benchmark of what a reasonable employer would do. Now, where might we have problems here on behalf of Marquis Moon in defending that decision? Well, already dealt with the question of notice. Was David Byrne on notice? Secondly, did he really intend this particular wrongdoing? Well, part of it, he intended the wrongdoing, is he had the mental capacity to do it. He knew it was wrong and he intended to do it. What we've had reference to here is drugs, stress, not thinking straight. That is clearly bringing in a situation where perhaps he should be given the benefit of the doubt. Certainly, as part of that investigation, it should have been, one of the steps that should have been taken is to find out more about his medical background, to assess whether his mental intention was lost at that time. He didn't have the capacity. He wasn't thinking straight. And a band of reasonable responses will probably include a final written warning. And as Sarah was referring there, it may well be that he should be given another chance. If the medical evidence was suggesting he wasn't thinking straight, if there was an issue about whether he was on notice as to where the line was, what I would really be saying to an employer is a final written warning is probably where an employment judge will say this case should have rested. Of course, if there is a commercial situation that he can't come back, it may well be that you move to a compromise agreement and you try and get him to leave the business, but you're going to have to pay something towards that. That's another area and not the subject of today. But the point being made is there's more than one way of skinning a cat. But certainly on the facts that we saw today, this dismissal would be an unfair dismissal and it's going to cost the organisation some money. Would have been in a better situation by having a policy, would have been in a better situation by following the lawyer's advice as well. However, if everyone does that, we don't make any money. Okay, so can I thank these two today for helping out in this, and thank everyone for watching. Hope it's been useful. Thank you very much.